Vu versus Thurston County Collision and Summit Towing. So there are two defendants in this case, Thurston County Collision, and it appears that the claim there is based on an agreement to do some repair work on a vehicle. Second defendant is Summit Towing, and the claim there appears to be based on Summit Towing impounding the plaintiff's vehicle at the request of Thurston County Collision, subsequently selling, auctioning that vehicle. That second part is what I want to address. Okay. And this is going to be a question to you, Ms. Vu. Ordinarily, when a vehicle is impounded at the request of a private party, the impounding authority provides notice, and then that triggers a timeline for an opportunity to challenge the impound. There's court procedure for that. And as part of the hearing in a case like that, you can recover costs, including the cost of the impound, the cost of storage, and also any damage that may have occurred to the vehicle or any loss of use of the vehicle. Those are all part of a cause of action in an impound hearing. And that's an exclusive remedy in the situation where a vehicle is impounded by a private party. In this case, reviewing the record, it doesn't appear that any such request was made within the statutorily allowed 10 days following the notice of the impound. So in my view, and I'll hear your position on this in case you have a different view, but it appears that the failure to request an impound hearing based on the claimed actions of Summit Towing, the failure to do that within the statutorily allowed 10 days precludes you bringing this claim in small claims against Summit Towing. So do you have any response as to why the ordinary impound hearing process was not used and not appropriate in that case?
So yes, Your Honor. So I had foot surgery during that time frame and recovery. So I didn't even go to my mailbox for like a month. And the most important thing is I was not expecting this at all because of the constant communication that was happening between me and TCC, the repair shop. We were communicating regularly, and just a sudden towing and auctioning off my car was so unexpected that I didn't think I had to go to the mailboxes to see what was going on, because we were doing all the communication via texting. So when I did open the mailbox, it was already past I guess they sent me like two notice, the first notice and then a second notice. And they may have met all the timelines, but that is the reason why I didn't get any of the notices until it was auctioned, after it was auctioned off. Now, the reason I named them as a defendant is when I went back to the office after I found out that it was auctioned off, I immediately went to the office, Summit Towing's office, and talked to Brooklyn. I suppose she's the manager or receptionist there, and she was the one that was mostly communicating with me. And I told her my situation and how that was an improper tow and impound and final auctioning off. And she said that it was abandonment because I said that I was in constant communication with TCC, so it's not abandonment at all. And she said, yes, she was aware. They were aware that we were in communication, but still, I did not pick up my car. So I don't know how they could have towed a car knowing that it wasn't an abandonment issue, which is just leaving a car there, not having heard from anybody. That would be abandonment. And also, I noticed in their exhibits they had some photos of their Summit Towing signs near the office, but I also have an exhibit Z to show that they didn't have a sign at the entrance. And I think the law says that they have to have signs at every entrance, and every visible part of like outside the building, inside the building. I felt like they knew what was going on and they just decided to take the action because they were sort of on the side of the defendant one, and then the pure refusal to just provide
Ms.
me
Vu, I'm going to
photos.
kind of, Ms. Vu, I'm
Okay,
going to stop you there. Okay.
okay,
These are the kind of challenges that can be raised in an impound hearing. And I don't think it's proper to revive a cause of action that's passed by bringing it in small claims. In other words, you can't extend the time allowed to challenge an impound by bringing it as a small claim instead of challenging the impound appropriately in the first place. My intent is to dismiss some towing from this case. So any part of this action that claims damages for Summit Towing impounding the vehicle and subsequently auctioning it after having impounded the vehicle at the request of defendant Thurston County Collision is going to be precluded. That the time for that cause of action passed. All right, so I'm going to go ahead and explain to you how we'll do this and get you sworn in, and I'll hear your claim and your defense. Okay. So what I'll do is I'll swear the parties in. Plaintiff will then go first and present their claim. Ms. Vu, you're the plaintiff in this case, so you'll present your case first. That means you'll testify about your claim and refer the court to any exhibits that have been properly filed in the court file. And then if you have any witnesses who you would like the court to hear from, I can swear them in and hear from them. After the plaintiff's had an opportunity to present their case, it'll be the defendant's turn. Same process. Mr. LaCroix, you'll tell me about your defense to the claim. Through your testimony, refer the court to any exhibits that have been properly filed. And then if you have any witnesses who you feel that I need to hear from, I will swear them in and hear from them. I'll hear from each party once. We won't go back and forth. I'm going to ask you to keep in mind a couple of things. When the other party is presenting their case, I'll ask you not to try and stop or interrupt them, even if you believe that they're telling me things that are inaccurate or not true. Please keep in mind that you will either get a chance in a few minutes to tell me your side of the story, or you've already told me your side of the story and I'm aware of it. I may need to ask you questions from time to time, and I'll do that in order to make sure I understand the nature of your claim or the nature of your defense. I may also ask questions or interrupt you from time to time to keep things focused on just the facts and circumstances that'll help me resolve this case, and not on things that are kind of tangential and don't really contribute toward getting a resolution to your case. All right. Now, I have dismissed Summit Towing as a defendant in this action, and unless you're going to testify as part of the defense, then you're free to go.
Thank you so much. You're gonna watch?
It's up to you. Totally free to do that.
I'm gonna go back to the office.
All right, I'll get the both of you sworn in then. So can I have you each raise your right hand? And do you each swear the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right, Ms. Vu, you're the plaintiff. You can go right ahead.
So on August 18, 2025, I got in a car accident on the freeway, and one of the wheels got hit, and just the corner of that left side, the front left side, and my car became disabled. So before I towed it to a shop, I called around to see. I called up quite a few shops to see if they would use used parts to fix my car, because obviously it's, my car is like 10 years old, and I just didn't. It would make no sense to have put in new parts. So I called around, and then I got to Thurston County Collision. Ellen McGill was the one whom I've been dealing with all this time. She was the manager, and she said, yeah, they use used parts. That's what they were going to do. And so just with that information alone, I decided to tow my car to have it towed to Thurston County Collision, and from here on, I'm gonna say TCC just to be give brief. So it was towed on August 18th by Black Lake. Well, anyways, Black Lake Towing. And when the car got towed, the office was closed and there was nobody there, and so we really didn't know what to do. I mean, I didn't know what to do, but the car was towed there. We were just like a couple minutes after 5, and the towing company demanded payment at a different rate. It was the different rate than what was told to me on the phone. And you can also see from their invoice that they canceled out a rate and they put another rate. And then he told me that on top of that, he wasn't happy about it because the driver wanted a higher rate and he didn't agree with what the office person said. But then I was willing to pay that. But then he said, well, I'm going to have to charge you extra for paying a credit card. And I didn't have cash. So in the end, I ended up not paying for it. And I said I was going to call their office, which I did the very same day. Nobody answered the phone. The next morning, nobody answered the phone. I told them, look, I have a situation here. How much do I owe? This was the rate that I understood it to be when I called you guys. Anyways, so that was that piece of it. And then, so on the 19th, I sent an email to TCC for an estimate. I said, I've dropped off my car. I just want to get an estimate. And then immediately after, I got an estimate on the 19th, very quickly. But then the estimate really didn't show any, it was all OEM, aftermarket OEM parts, new parts. It didn't indicate at all that they were going to use used parts. And this is where in my suit, I found out that there's a kind of deceptive, and it may be kind of a trade issue here, but I'm not going to focus on that in this suit. So anyway, so I asked about that in email, which is in in an exhibit 3A. 3A says, I drop off your car and I'm interested in using used parts only. And then I would be there on August 20th to take photos on my car. And on the 19th, and then yeah, exhibit 3B continues to say that I wanted that I was surprised that they weren't going to use used parts. And just by the rate at which the estimate came back, like almost immediately, gave me confirmed that they actually didn't really make an effort to go look for the used parts. And I really was expecting them to take some time. And then exhibit 3B will show that no, they don't have, they're saying that used parts are more expensive than new parts, which made no sense to me. But basically I told my car there, and then I'm being told, no, we're going to have to use new parts. So this is why it took me a little while to kind of decide what I was going to do, because it was not what I expected. And then, so when I showed up, and I asked all these questions in email as well, and it's in the exhibit. So on the 20th, I showed up to take photos of my car. And by that, when I got there, actually exhibit 1A, you can see that was the condition of my car when I dropped it off. It was just the front. It was the front wheel and just the front left corner of it that was damaged. And then I showed exhibit 1B. The interior of the car was perfect. There was nothing, I didn't see any damage at all. It was all like exterior stuff to be fixed. So on the 20th August, in the afternoon, I went to take photos of my car, and I realized that I saw that it was already kind of dismantled. I thought they were going to wait for me, instructions on how I want this done, make agreements on what's going to happen, but they had already disassembled the fender and a bunch of other things that I didn't know what happened because it just looked like a different car. And so I have pictures of that too, which, let me see where they are, but it's some, okay, so Your Honor, what I'm going to do is I'm going to give you kind of a brief overview, and then I'm going to go through the exhibits to kind of capture any gaps there, if there were any gaps. Is that approach okay by you? instead of going back and forth between the exhibits and my accounting of what happened.
Yeah, I mean, you
Okay.
can, yeah, present your case, yeah, however
Okay,
you'd like.
however.
If I
All
find
right.
it confusing, I'll let you know.
You find it confusing?
No, if I do, I'll let you know.
Oh,
Otherwise,
okay.
go ahead.
Okay, sorry. So anyway, yeah, it was already dismantled and it has already gone through a uh I I don't know if they call it at that time. You know, there were times when they say it was a tear down, and at times they were saying it was not a tear down. I had no idea, but I knew that tear down sounds like a really serious thing. But it looked like the whole fender was out, and I don't know, and there were some parts that had been pulled out, perhaps to see what was behind those parts. But that was all done before they had a conversation with me. And then they had me sign it looked like a general repair authorization, which is um, exhibit 4. So my understanding of this repair authorization is it was written in very general, high level language. It's just that I'm allowing them to inspect the car. I was not expecting them to do tear down or any kind of major damage to the car where they couldn't put any parts back. Because at that point, I wasn't sure if I was gonna they were going to be the repair shop. I just wanted to get an estimate. But when I got there on the 20th, I saw things disassembled. I was starting to wonder how I was gonna, if I didn't go with them, how I was gonna tow this car to some other place because there were parts flying all over the place. So they had me sign this on the 20th, this repair authorization, and I read it, and it said the storage fee would only be incurred if the car was not repairable or if it was repaired and I didn't pick it up, which I knew in none of those situations would ever happen. If I had it repaired, why wouldn't I pick it up? Why would I leave it there? I want to drive it. And then I knew it was repairable because I just got an estimate. I got the estimate from them on the 19th saying that it was repairable at about $6,000. So I signed it, and so what happened was then this authorization shows that it was dated on the 18th, but really I signed it on the 20th, and you can see that it's a different handwriting. It was backdated, and I didn't notice it then, and or maybe I did. I don't know if I noticed that, but I didn't think it mattered until now. But I, in retrospect, I'm thinking that they actually did the disassembly and initial teardown is what I call it, even before I signed the authorization. So when I got there, Ellen asked me if it was okay for them. They've done some work, some tear down work already, but if it was okay for her to lift up the car and look underneath because they couldn't see possibly some of the damages. So at that point, I realized the $6,000 wasn't really the full amount. It could be more. And so I said it was okay for you to lift up the car. It would be of no damage to the car, but I was very specific that I don't want any damage to the car, or that it was going to be a big major thing where I was going to be charged for it. And I don't see any tear down charges being mentioned in this general authorization either. So so I said, okay, that's what I said. Okay, if you're not going to charge me for it, I don't see why you couldn't look under the car. So, and she said, no, you're not going to be charged for that until we you approve the estimate and we move forward with it. And so that's the understanding. And it's the general understanding of what happens when you take a shop to a mechanic is they don't charge you to get the estimate is free. And you don't actually get charged for repairs until it happens, or they don't do any tear down work or whatever until it's all approved and discussed. So so I left the car there, and I actually hadn't heard of, I just hadn't heard from them in a while. And but I did get, I know Alan did say that there might be more charges following that, but it was never solid or final, just that there could be more depending on whether the arms control is that's. So to me, it was this is really confusing and scary. I don't know what I'm going to do. I want to fix my car, but everything was just so out there and not tied up that I was afraid what the final cost was going to be. And in this general authorization, it did not say, I think the RCW says that that the sub that they can't charge more than 10% uh, of the final the final estimate. It doesn't even say that, and I didn't know. So in my mind, I thought, hey, this final bill could be anything, right? If it was there, and I would have known. Okay, so if the final bill was $10,000, they could only charge me an extra 10% supplement. I would have felt a lot better. And I found out about all these things when, after I was thinking I was going to file a suit. So, that was the end of that conversation, so to speak. But then I hadn't heard from them about, I guess, for a while. And then on September, was it? Yeah. One thing is when I was there, I did notice the customer's bill of rights sign. It was inside the office, but it was behind a door. And then a door was open where you really couldn't see it most of the time. It was not somewhere where it's clearly visible and seen by the customer. And on 21st on August, so on August 21st, from August 21st to September 3rd, we were actively engaged in negotiation regarding the repairs. What is this and what is that? What if, and what if I repair this or not? And basically, I was just really disappointed that they were not using used parts after all. So on September 4th, so I had a work issue that I had to leave. So I told them, hey, I am going to be leaving the state. Actually, I was leaving the country. Is it going to be okay if I left my car there? And they said yes. That was all they said. Yes, you can leave your car there. So, because I was still trying to get information on what else was wrong with my car outside of the $6,000 estimate that I was, so we kept negotiating and asking questions throughout that time. And then so September 5th to September 22nd, we continued to engage in conversation. And during that time, there was no mention of, hey, your car's been here for too long, this is not okay, or whatever it is that they needed to bring up. Because during that time, I was thinking I wasn't going to be incurring any storage costs based on that repair authorization that I signed. It said storage fees would only be incurred if I had repaired my car. So I felt like I was okay. And then before I left, I got an okay from Ellen, the manager, that I could leave my car there. Because the fact of the matter is, my house is only 2 miles from the repair shop. It was not okay. I would have easily towed my car from the repair shop to my house. That would have been no problem at all. I had a driveway and a space next to a driveway that could have accommodated my car, but I was really wanting the car.
Ms. Boo, I'm gonna kind of stop you here. All right,
Okay.
If we're gonna get through this, we're gonna have to focus on relevant facts here. Okay, this is kind of so far this is just kind of like a narrative of everything, and I'm going to have to focus this if we're going to get down to the sort of legally important facts that are going to get to where we can decide this. So,
okay.
I need to know a couple. Yeah, I need to know a couple of things, and keep in mind, you've submitted all this stuff in writing. It's not, you don't have to say it again, so to speak, in order for it to be part of the case. It's the material that you've submitted in writing is part of the record in the case. So, what I would like to know is, first of all, did you pay Thurston County Collision any money?
No, I didn't. They didn't ask for it.
So your claim then is based on the fact that they had your car towed away and you lost your car.
Yes, I lost my car, and and I had I looked up the Kelly Blue Book value of my car, which was in, I think one of the last few exhibits for
Yeah.
$9,300. And I subtracted, according to my research, of what insurance companies do with the damaged cars, you deduct 23%, because the $6,000 included like processes and stuff. So from my research, you would only take off 23% or so on the damage. So I figured my car was worth about $7,000 at the time that they at the time the value of my car. And after the teardown, I did send an estimate request to Capital Collision after they did their teardown. So TCC said that it would take 6,000 to do to repair, at least initially. But then Capital Collision said after what they did to my car that that really the damage was $13,000. So what I'm
Let
trying to
me
say,
ask you, let me ask you this then. At the time that your car was delivered to Thurston County Collision, after it had been involved in a collision, in your view, at that moment, how much was your car worth?
in my view, my car was worth about I thought it was worth about $6,000 to $7,000.
Okay.
I mean, I did
That's-
look up the Blue Book value also, but that was, but it wasn't as specific as the Kelly Blue Book, which is what I then later on found out was actually worth more than that.
Okay. And those Kelly Blue Book values, are they based on a car that's not been involved in a collision?
Yes, yes.
Okay. So
And that's
your
why I
view,
took off. That's why I took off 23% for the damage, which was what
okay.
I learned as
And
what insurance was.
how did you come up with deducting 23%? Why is that the amount?
So according to my research, that's what insurance companies do to determine damage. Like if they were to pay out somebody that said they had a car, it was damaged. So that's what they would do is they take out 23%
Okay.
or around
Now,
23%.
so in your view, that's the appropriate way to value your car. And you're claiming that the reason that Thurston County Collision owes you that value is because they had your car towed away and it's since been auctioned off. And I would like to know succinctly, in your view, why it was wrong for Thurston County Collision to have your car towed away.
It was wrong because we were in communication throughout that time that first of all so they wanted me they had never I there were a few times when I said I'm gonna come and pick up my car. I don't think that I owe you this storage fees, and you guys didn't do any repair. I didn't authorize any repair. I'm glad to come pick it up several times, but every single time I said that, they took my car hostage and said, no, you can't do that unless you paid us the $6,000 for a long time. They said there was $6,000 and they kept adding all kinds of fees. I have an exhibit that shows that there's admin fee, which was never mentioned anywhere, not even in the repair authorization agreement. And then they added in another exhibit, they added storage, there's admin, and then they added storage admin, and then every time it's a different fee that they kept adding on to it. So so no, I'm sorry, now I lost my train of thought. What was your question again? I'm so sorry.
All right. You said your car was brought into Thurston County Collision in August of 2025.
Yes.
When was it towed away?
It was towed in January. They gave me, it looks like
26.
6.
It was
Yeah.
towed away in January 2026.
No, sorry. It was December 16th. And it was just auctioned off in January.
Okay, so December of 2025.
Yes.
Okay. Now, it seems to me, and you know, I'm not an expert this is just my impression that looks like your car was there from August to December. So that'd be roughly about 5 months. And that seems like a long time for a car to be left at a collision repair shop unresolved. I mean,
Well,
that seems unusual to me.
it is unusual, but I wanna point out to the fact if you look at the text messages, is like I want to focus on the fact that I have tried many times to tell them that as soon as I came back from out of the country, I said even before I came back out of the country, I said I wanted to pick up my car, but they said I owed them $6,000, which I disagree with. And so that was it wasn't
what was the reason they offered you that you owed them $6,000 in order to be able to get your car?
they said I owed them first I either had to repair or I owed them storage.
Because it was sitting there at their lot for those 5 months.
Well, at the time I wanted to pick up my car, it was only 2 months.
Mhm.
So, so because they held my car hostage and they had a condition to the release of my car, they would not. So I could not pick up my car. And so that was what happened. And
Mhm.
at the very end, they gave me a short window period that says, "Hey, forget about 6,000." Like they keep changing their prices and forget about the 6,000, but I think you owe us the toll money. And then because I told them in one of the exhibits, and I have email for that or text for that. That's something I want to deal with directly with that company. It's not a debt that I owe them for, and you like they couldn't just hold on to my car because of something that they were trying to collect for someone else. And aside from that, the amount that they said was owed for the tow was actually different than the amount that was on the invoice. It was a small difference, but it made me just realize I just made me wonder what was going on. And they sent me a copy of the invoice. They didn't send me like any payment evidence or anything, but basically, I wanted to deal with them directly with the person that provided me service, and I told them that. Um, so anyways, so all this time I was like in communication with them and then when they said come pick up your car again, there was not a single communication from them that said you can come pick up your car. It was always conditioned upon some sort of payment or you can't get your car. So it wasn't easy. It
Okay.
was like, you know what I mean? So
So
and
they
it was
wanted
more like
money from you to release the car,
I'm
and
sorry.
then they wanted money from you to release the car, and you
Spec-
left the car there.
Yeah, they wanted money that they wanted specifically the $6,000, which I didn't agree with because $6,000 for 2 months is crazy and I didn't sign and they kept pointing to the authorization which clearly said that storage would only be owed if storage would only be owed if I had it repaired. So I wanted to get my car, but they wouldn't let me have my car was the situation. And then when they told me finally they said, "Come pick up your car." I mean, we were in communication and they could have said, "Today's the day that we're going to impound tow your car or impound or whatnot." Because the only form of communication we were using was text, and they did not tell me that. And then they filed an abandonment, which the car was not abandoned by any means, any definition of the law. I was in constant communication with them. They did not file a possessory lien. If they felt like I owe them money, wouldn't that be the process they would have taken and I would have gotten notice of it? And then I would have known that that's what they wanted to do and maybe prevented the auction from happening. But they didn't do that either. So uh and then all of a sudden, my car was towed. And it's unfortunate that I didn't pick up my mail until the very end, or I would have objected to it. Anyway, so
We're gonna have to keep this moving. Now, you realize that that Thurston County Collision has filed a counterclaim against you, right?
yes, to which I'm gonna have to question the service of that, because I looked at the declaration and it wasn't clear to me what if they handed it to somebody. They surely didn't hand it to me. I was not even
Well,
home.
yeah, I don't know. We'll have to see what they show.
And so there wasn't a whole lot of description about the countersuit except that I owe them $6,000. And anyways, that um, and so in December, I did tell them that I'm trying to get I'm trying to get somebody to tow it, but it was the holidays and it was getting really hard to find somebody. I did try and call around, but nobody actually returned my call. I said, hey, just give me a couple weeks in January. I'm for sure gonna come pick it up. They didn't respond to me. And so anyway, yeah, so they just had it towed for abandonment reasons, and they followed the abandonment procedure, which I feel that procedurally that was wrong too, and they didn't do the possessory lien. If they felt I really owed them money, that's the process they should have gone through, and I would have gotten the proper service notification. So anyway,
All right, I'm gonna hear from the defense,
oh, one more
and
thing.
I'll
So the repair estimate that I saw that the defendant provided was a different one than they provided to me. The one they provided to me was 3 pages. This one had like a lot of pages, and it showed that there were parts coming from all over the place, but that's not the one I got.
all right. Mr. LaCroix.
Yeah, thank you. Your Honor, Thurston County Collision is a local family-owned business. Our storage space is limited. We don't have capacity to hold vehicles that aren't being worked on. So, a car occupying our lot for months without a repair decision is a real cost to us. With that context, I'd like to walk through the timeline. I'll try to keep it brief and to the point, because the records show that the vehicle sat at our shop for nearly 4 months, while the owner repeatedly delayed deciding what to do, never paid anything towards the balance, and did not receive the vehicle even when offered to release it for the tow bill alone. So the timeline, the Mazda was towed to our shop on August 18th. Exhibit 2, the Black Hill towing bill. The owner signed our repair authorization, Exhibit 1. The work order for this job was open on August 19th. From August 19th onward, we communicated actively about the estimate, the parts, and the scope of the repair. That's in Exhibit 5, images 1 through 6. On September 4th, the owner told us she had an urgent need to leave the state, and she would, in her words, most likely fix it, but needed time to think. That's Exhibit 5, image 4. We agreed to give her that time. On September 22nd, she told us she was out of the country and would not be back until mid-October. Exhibit 5, image 6. That was roughly a month with the vehicle sitting in our shop and no decision made. When she re-engaged in late October, about 2 months after the car came in, we explained the outstanding charges. She disputed them. Exhibit 5, images 10 through 17. I point the court to one message in particular. On October 24, she wrote that she would owe the tow charges and could pay them separately. Exhibit 5, image 11. Over these same days, she raised several possibilities, deeding the vehicle to us, having a junkyard take it, selling to us, and then withdrew them, which she was bringing up all these different things, stating October 27th that she had not agreed to deed the car, Exhibit 5, image 18 through 24. And remember, through all of this, no payment was made and the vehicle was not retrieved. After about a month with no resolution, she contacted us again on November 28th. That's Exhibit 5, image 25. And really to the heart of it, by December 3rd, the car had been with us for over 3 months. We offered to release it if the owner would simply reimburse us for the money that we had out of pocket for the towing bill, $362.01. And we would set aside any other invoices that we had or claims that we had for. If you go back to connect the two things, on October 24th, she said in her own words that she owed the tow charges. And that's Exhibit 5, image 11. On December 3rd, we offered to release for exactly that, the tow charge alone. It was, it was the very resolution she had, that she said she would accept. She did not pay it. She questioned the amount and asked the tow company's name and the bill and the signed bill, which we provided in Exhibit 5, image 28. So from December 3rd to December 16th, the offer stood. The owner had almost 2 weeks to pay the $362 bill, the amount she acknowledged, and take the car. Within that window, she made no payment and did not retrieve the vehicle. That's in Exhibit 5, image 28 through 30. On December 16th, we contacted Summit Towing to remove the vehicle because nothing has been done. And you have the documents for the Summit Towing and impounding process in their exhibits. Even on December 21st, the owner messaged to arrange removal, but now even pushing it out to January timeframe. By that time, it's been Summit Towing has it in their position, so that was essentially the end of our involvement in it. So to summarize, nearly 4 months was at our shop from August 18th. That the entire time the owner paid nothing towards the balance. She left the state in early September, was out of the country until mid-October, and went roughly another month before resurfacing in November 28th. We stayed responsive throughout. And we offered a resolution on October or December 3rd. And she had nearly 2 weeks to pay it and pick up her car. So from that, then it was removed from our lot.
Your Honor, can I say something?
Hey, do you remember what I said at the beginning?
Yeah, I'm asking if it's okay for me to say something.
Is it something you haven't already told me?
Yes, it's
All right.
kind of responding to what he had said to just set the timeline straight.
We're very transparent in the timeline. It's all there in the text messages.
So what I wanted to say is that during this exactly that the momentum has been slow because my car has been held hostage. And there was not a single time when they said, come pick up your car. That dispute payment should have been something separate, but they have taken a dispute payment and made it into a lien or vehicle abandonment situation, because they don't. It looks like they didn't just want to follow the dispute payment situation where it would be different. I owe you. If they felt that I owed them money, then it would have been send me to collection. But instead, they sold my car and call it a vehicle abandonment. And really, they gave me 2 weeks. By the time that all this time, the 4 months, whatnot, it had always been they insisted on $6,000 or you're not getting your car back. And so on December 3rd, like he said, Jeff said, they finally said, okay, we'll let you take the car back for 300 and some dollars. And that amount was not the same as the invoice amount. It was close, but it wasn't. But it just made me wonder what they were doing. And they gave me 2 weeks, but they didn't say they gave me 2 weeks. We were communicating and I was expecting them to communicate and to say, look, this has been 2 weeks, we're going to do it now, or you have this week to do it or whatnot. We're going to tow it. So I thought we were still in negotiation or just talking things through.
Okay,
But
Ms. Vu, we're
yeah.
repeating things that have already been
Okay,
said.
all right.
The case. So, all right, I think, I mean, I've heard the case. I understand the nature of the claim and the nature of the defense and the nature of the counterclaim. And this is probably a good example of something that I do think that the parties could have resolved this probably along the way, even before it became a case in court. But I come back to the sort of the original principles. The plaintiff has the burden of proving their claim by a preponderance of the evidence, meaning the greater weight of the evidence. And I don't think that any reasonable person could believe that they could have a wrecked vehicle towed to a repair yard and then have it remain there for 4 or 5 months without that car being repaired, or if there's no agreement or bargain to go ahead and repair it, to take it away to someplace else and have it worked on by somebody else. It's just not reasonable. No reasonable person would believe that they could leave a damaged car at a repair shop indefinitely like that. That's just not that's not what they're in business to do. That doesn't seem reasonable under any analysis. Even if you were talking with them, that doesn't mean that it's reasonable to expect that they would allow a damaged car to sit on their property completely free indefinitely. It just makes no sense. So a reasonable person would either have the vehicle repaired at that collision shop, or if they didn't think that that collision shop was qualified to do it, or they were too expensive or something like that, they would have that car taken to another place that was satisfactory to them. That's what a reasonable person would do. So I cannot believe and will not accept that there was an agreement on the part of Thurston County Collision to indefinitely retain this car at no cost, and at the same time not be actively working on repairing it. So any reasonable business owner with a vehicle on their property that was not being worked on as part of their business, they would have it towed away or have it removed in some way because it's on their property for no productive reason. I saw in the exhibits that Summit Towing was the impounder that they work with. There were signs up, notice was provided. Ms. Vu is very clear that she's not particularly diligent about collecting her notices, and that might explain why the vehicle was towed away and that the subsequent notice of right to an impound was not acted on in a timely way. So I just cannot award any damages based on that transaction. The behavior that Thurston County Collision engaged in there was perfectly reasonable. They just weren't going to retain this vehicle indefinitely. As far as damages, I mean, if they had wrongfully had that vehicle towed away and disposed of, they would owe you some damages for that. But they didn't. They provided notice. They said, come get it or we're going to have it towed away. That's exactly what happened. If you believe that Summit Towing did something wrong, you would have exercised your rights under the impound statute and challenged that tow as wrongful and potentially been entitled to damages there. But you're not. You didn't exercise that. So on the underlying claim, there'll be no damages awarded. As far as the counterclaim, I know there was a counterclaim made for $6,475.26. It's not entirely clear to me what that's based on. I know that it would be reasonable that Thurston County Collision would incur some costs for having retained the vehicle over a period of time that lengthy, which they did, but it also doesn't appear that Thurston County Collision undertook to repair the car or procure any parts or anything, or incur any expenses related to attempting to repair the car. So I think it would be reasonable under the circumstances here to award some amount for the time that the Thurston County Collision retained the car for the convenience of Ms. Vu. And I think a reasonable amount for that would be $500. So I will award no damages on the underlying claim. I will award $500 in damages on the counterclaim. And there were no filing fee for the counterclaim. And Mr. LaCroix, did you have to pay the process server to serve the counterclaim on Ms. Vu?
Yes, $120.
120. All right, that's a reasonable and common amount. So the amount awarded under the counterclaim will be a total of $620.
So, Your Honor, even though it was not valid service.
No, I'm finding that the service was valid based on the declaration of service that was filed. It was also timely under the small claims filing rules. All right, I'm writing a judgment to the effect of my oral ruling, filing that judgment with the court clerk, and it'll be available to both of you from the court clerk's office at any time. All right, that will conclude the case for today.